Hey everyone, Scott Wells here again, one of your lead patrol tactics instructors at CJTC on the BLIA side. And today we're going to talk about use of force. You'll see there it says one of three. I tried my best to condense this material down into one 2-hour block of training, and I was having a really hard time doing it and just struggled with that. So I'm going to break it down into 3 separate training sessions. Probably all of them won't go that long. They'll probably be a little bit shorter than that if I can talk fast enough. So today we're going to really focus pretty heavily on Graham, Graham versus Connor, the factors out of Graham with the plus added to it from cases like Chu versus Gates and Glenn versus Washington County and things like that. The quantum of force, turns out that term was coined by Taser International's litigation expert, Michael Brave. It is a huge concept to grasp for use of force, but super important. And the objective reasonableness standard, of course, we'll cover some RCW definitions and go over some of those things. But I want to start off with just citing a quote out of a paper or an article. More accurately, the article was put out, it was published in March of this year by the National Institute of Justice, and in the article, which was called Overview of Police Use of Force, they stated that there is no single universally agreed upon definition of use of force, and the IACP, the International Association of Chiefs of Police, did their best to contain it. They said that if they had to describe use of force, they would describe it as the amount of effort required by police to compel compliance by an unwilling subject. So when we even have, entities like that can't box it in and contain it, and as a matter of fact, the Supreme Court also says that they're not capable of giving a precise mechanical definition of it as well. So it's a hard topic to cover because it's squishy. It's case by case basis and determining reasonableness and quantum of force. So I thought I would share that with you before we got started here. So I want to start out with saying big thanks to Sean Hendrickson and Rich Lee for doing the heavy lifting for so long on this topic. Those guys have been in the trenches teaching this for a long time, and we decided that we were going to put use of force, the instruction of it, under the patrol tactics side, because we thought of course it makes sense to be in DT and it makes sense to be in firearms, but when you meld all those things together, probably makes the most sense to put it again like the class course under patrol tactics. So anytime I hear someone talking about use of force, I like to know what's your background in it, and how are you qualified to even talk about it? So just give you a little bit of background on myself. I was the use of force instructor and program manager of that program for the Snohomish County Sheriff's Office from 2014 to 2017. Actually started training cops in ground survival tactics in 2012, primarily based on my jiu-jitsu background. Some people knew about it and they asked if I could share some things, and it kind of went from there. So in 2014, I went down to Oregon and got a certification through Krav Maga Worldwide, and was just absolutely fascinated with not just the content of it, but the instructional delivery was super fascinating. The instructor was really engaging. I still stay in contact with him via email. He's a great guy, and I brought that back to our agency, and primarily our use of force, primarily trained under KMWW's instruction. During that time, I was a Taser International certified instructor. Taser International now is Axon. I don't hold a cert under Axon, but I did under Taser International. Through ASP, I received a baton, a handcuff, a flashlight instructor cert. I don't think that one expires, actually, but you should stay in practice, of course. More towards the academic side of things, in 2010, I went to San Jose and I went through the week course with Dr. Bill Lewinsky and others. and received a Force Science Institute cert through the Force Science Institute. It was really interesting. It's probably one of the more challenging classes that I've been through in law enforcement. And then through CJTC, I received my level 1 pistol instructor cert and my patrol rifle instructor cert. Obviously, there's use of force elements involved in those classes as well. So qualifications further, NCBRT, National Center for Biomed Research and Training. I received an active shooter instructor through them. I can't remember what year that was, but I ended up holding a regional training up in Snohomish County based on that material. I received an instructor cert through the use of force and liability management from ACCJT. It's the American Council on Criminal Justice Training. The gentleman who runs that program is Howard Webb. He wrote the book Managing the Use of Force Incident, and then he also wrote the 48 Tenets of Officer Survival. He designed Hitman training gear. He's an internationally recognized expert on the use of force. And then why are these in here? It really played a lot into my investigation of officer-involved shootings scenes, other shooting scenes as well. But in 2009, I got a shooting scene reconstruction cert through Nodell Scientific. Matt Nodell used to work for the Washington State Patrol Crime Lab, and then he branched off and started his own company. So that was my first look at shooting scene recon, just to get my feet wet. And then after a few years went by, I developed a passion for investigating scenes involving firearms and shootings, and went to the best source I possibly could, which was Mike Hague with Forensic Firearms. Mike Hague's dad, actually Luke, Lucian Hague, but everybody calls him Luke, wrote what is considered probably the Bible on this subject matter. Mike and Luke both went, there's a Nova special that shows both of them doing a shooting reconstruction of the Kennedy assassination. They had to get special permits to go into Dealey Plaza, and it was pretty fascinating. So topics like fundamentals of trajectory, terminal ballistics, shot sequencing in the limited universe, and scientific method, and all of those came into play, but really put that into the realm of officer-involved shootings. It was pretty fascinating. So along those lines, just again briefly, I was in a major crimes unit for 7.5, almost 8 years, homicide and assault team. And with that, a collateral duty was during that same period of time. I was on our SMART team, which investigates all officer-involved shootings, significant officer use of force, and then unfortunately also in the line of duty deaths. I was actually the co-lead on a case involving an officer who was charged with second-degree murder and a lesser included of manslaughter in the first degree during that time, and then also investigated 2 line-of-duty deaths, one of which was Deputy Ann Jackson with the Skagit County Sheriff's Office, and the other was Officer Jamie Bendel with the Washington State Department of Corrections. So I've spoken with a lot of officers and interviewed them, and have had lengthy discussions with officers who have used deadly force in the field. So that's how that would apply. And then just some of my interests, as far as the martial arts realm goes, the lion's share of my background is in Brazilian Jiu-Jitsu. 2014, got my brown belt. Trained with some really some kind of heavy hitters in the industry. I have a lifetime bronze coaches cert under USA Wrestling, and then just some of my other. It's kind of a smattering. It's kind of a smorgasbord of stuff regarding martial arts. It's pretty interesting to talk to recruits about use of force, because I didn't teach this at the academy, and but I did teach criminal procedures, and that touches use of force as well. So topics would come up, really come up in police liability class. And so in what lens or in what ways is my use of force going to be viewed, or can it be viewed? And we know that it can and will be looked at federally under the federal law, under federal constitution, Washington state law, Washington State Constitution, case law, federally and state, and as well as department policy. So when I say federally and I say Fourth Amendment, the students who don't know look at me and go, well, I thought that the Fourth Amendment involved unlawful searches and seizures. And I say, you're right, it does. However, a police officer's use of force on a citizen is deemed a seizure. It's the U.S. courts have stated that actually in deadly force, it's unmatched. There's nothing like it. It's the ultimate seizure. So it's in that way that an officer's use of force is viewed under the Fourth Amendment. Federal case law decisions. Today we're going to go heavy on Graham. The next presentation we'll talk heavy on Garner. But some case law decisions here. Graham and Garner are landmark ones. But also Chu versus Gates out of L.A., Brian v. McPherson, Diorly, and Glenn versus Washington County. I'll give you kind of a highlight of Glenn versus Washington County towards the end of today. Washington state law, RCW, we're going to look at the definition of necessary. We're going to look at the definition of deadly force. And we're going to look at what do they mean when they say in good faith. So we'll look at those as well. Some Washington state decisions. These cases were actually decided in U.S. District Court as well, but more closer to home. Brooks versus City of Seattle and Beaver v. City of Federal Way, both were taser cases. So we'll talk a little bit about those as well. And then, of course, department policy. Are your actions consistent and fall in line with your agency policy? So in the criminal procedures realm, like I said before, when we talk about seizures of people and we talk about the seizure continuum, social contacts, Terry's, or more Terry stops, yes, I actually like to call them what they actually are, and they're an investigative detention under Terry, because words are important. So, and then PC to arrest. Of course, when we talk about frisk and search, putting hands on people, we talk about the Fourth Amendment. So I showed them the Fourth Amendment, and then again in the use of force realm, the use of force by police on a citizen is a seizure, and once they get the grasp of that pretty quick, I think, especially when you start talking about the seizure continuum. So Graham versus Connor, just to kind of start with here, decided in 1989, and it's the law of the land as far as use of force goes, still is. But why is it important? And it's important because not only is it the law of the land, but it's present. Graham is present in any use of force event, whether it's deadly force or not. The courts are always going to ask the Graham factor questions. They're going to always ask, what was the immediate threat to the safety of the officer or others? They're going to ask, what was the severity of the crime? They're going to ask, was there active resistance, and were there attempts to escape, evade, arrest by flight? And then the plus to Graham being from cases like Chu versus Gates and Glenn versus Washington County and others that address were there reasonable, less intrusive alternatives to the force employed. And so we'll talk about that a little bit more in depth, but the Graham factors plus, I just ran through those with you. Some instructors, it depends on the instructor, some break the Graham factors into 4, some break them into 3. And when they break them into 3, they combine active resistance and attempts to escape or evade arrest by flight. I'm one of those instructors that breaks it into 4. So when I say 4 Graham factors, I really mean 5 when we're including the plus, if that makes sense. So what was the immediate threat to the safety of the officers or others would be number 1. Number 2 is severity of the crime. Number 3 would be, was there active resistance? And number 4 would be attempts to escape or evade arrest by flight, plus reasonable, less intrusive alternatives to the use of force. And it's important to note that when they say reasonable alternatives, they're not saying all alternatives. They're saying reasonable ones. The objective reasonableness standard, what is that? We'll talk about that. Objective reasonableness in the sense of at the inception of the incident, the degree of force used, and the duration. So all of which are judged under the objective reasonableness standard. Was the seizure reasonable in the first place? Was the amount or type of force used reasonable? And how long did it last? How long did it go on? What was the duration of it? And so in all three of those, the objective reasonableness standard needs to be met. And then level of intrusion weighed against a governmental interest. That sounds really kind of confusing sometimes, especially to recruits. And so I explain it to them this way, and I get this from Tim Miller, who's the subject matter expert for FLETC. And he explains it this way, and I think it's a really good way to explain it. It's really not that difficult. Level of intrusion is what did the officer do? And governmental interest is why did they do it? Is probably the best way, at least that I've found, to explain that. So just again, to run through the Graham factors and the plus to them, top of the list is immediate threat to the safety of the officer or others. That's at the top of the list because there are other cases that have reprioritized the Graham factors, putting immediate threat at the top, and immediate threat is generally speaking, the most well-respected of the Graham factors. Severity of the crime comes into play, obviously weighing the type of crime that the officer believes that they're dealing with at the time. Is it a shoplift? That really carries no, minus behavior, really carries no element of danger versus, say, a robbery. It's a factor. Active resistance, note that it doesn't say passive resistance. Do we have active resistance by the violator taking place? And are there attempts to escape or evade arrest via flight? And then the plus to those are, again, were there less intrusive, reasonable alternatives to the use of force? Were proper warnings given? And did the officer, should they have known, or was it relatively apparent that the person that we were dealing with was an emotionally disturbed person or falls into that category? Because it makes a difference in the governmental interest. Later on, I'll get a little bit more in depth in the governmental interest involved in these types of cases, but let's just say minus no criminal element involved and we're dealing with an emotionally disturbed person, that the governmental interest is diminished or decreased. Warnings, really, the courts address warnings in the use of deadly force, and they say when feasible. It's not always feasible. There may be times where we're using great tactics and we're able to establish dialogue and we can have a longer rapport or conversation with somebody, but that's not always possible either. So a warning will never hurt an officer's use of force, but then again, it's also not always feasible. So Sean Hendrickson came up with this fantastic mnemonic. I think even he himself would tell you it's not an equation. It's a way for students to understand and put this together. So really what it is a mnemonic. It's a grouping of things or words or letters to help you understand a concept. And so what does it mean? Well, the police lawful use of force equals, under the totality of circumstances, were my actions objectively reasonable under totality. And 643 stands for 6 situational factors, the 4 factors in Graham. If you were to instruct it in a manner that the Graham factors themselves would be 3 plus reasonable less intrusive alternatives. And then the 3 types of force, and then you'll see 2 plus signs and plus plus, and I'll talk about what those are. Those are PACE and the probable cause standard. So again, the police lawful use of force equals objective reasonableness under the totality of the circumstances. Totality being, what did the officer reasonably know, perceive at the time? We know that what an officer learns after the fact is completely irrelevant to their use of force. So if we learn we were involved in a use of force incident, and let's take Hudspeth v. City of Shreveport, for example, the officer employs deadly force because he believed that the subject held was, based on their posture and demeanor and actions, presented a firearm. Now, it wasn't a firearm, it was a silver cell phone. But let's say that, just for the sake of argument, that the officer in that case, after the lawful use of force, goes up to medically intervene, handcuffs the subject, and does all of those things, and then they determine that, well, in the waistband, didn't see it at the time, but now I see that the subject has a firearm on them. Well, that makes my use of force more justifiable at that point, and that's just not true, because we can't consider that after the fact stuff that we learn and put that into the equation. So the 6 situational factors, the 4 Graham factors, and then the 3 types of force. The 6 situational factors, we're going to run through those. Number 1, do we know the history of the violator? Do we have any data on that? Is psychiatric and or violent history? Number of officers v. violators. That cuts both ways, though. So you could be outnumbered, and that may have an effect, and probably will have an effect on your use of force at that point. But also, if we flip the script, more officers v. subjects, that's also a factor. So it cuts both ways. Mismatch, of course, age, size, condition, skill level involved. Environmental factors, things like weather. I'm actually sitting in my car recording this, and I'm looking at it's raining. The surface of the pavement is relatively slippery. The terrain is sloped. You might become unbalanced based on the type of terrain you're on. It could be gravel and rock. It could be dirt. It could be linoleum, whatever. So those things do factor in. Does the subject have access to weapons? And injury and exhaustion level are part. So those are the 6. The 4 Graham factors, again, just going to put these up here. We know what those are, again, in order. Immediate threat listed at the top. And, of course, the plus being less intrusive alternatives to the use of force employed. 3 types of force. Previously, it was explained in this way. It was explained that there's 3 types of force, and those are control, impede, and stop. And so we got the gist of that. We know what that means, but a little bit confusing, because when we said control, we really meant force. Force leading up to intermediate force. So presence, verbal commands, display of a force option, so display of a weapon. The ASP is out and it is extended, or the straight stick is in hand, hasn't been used yet, but it is held, maybe port arms or something like that. Taser deployed, not deployed, but out of the holster, maybe with the laser and the light on, but no actual deployment of it, or display of a firearm without any shots being fired, or really any pointing in. Those would fall under category of force. Also, touching, guidance, direction, and things like those would fall under force. And so previously, when it was couched as control, that's really what we were talking about, the first phases there. Intermediate force being what was previously referred to as impede force. The courts really only address deadly force and intermediate force in case law. They don't say it as impede. They don't say it as stop, because the use of an intermediate force option may stop subject's actions or what they were doing, but it's not deadly force. So the way that we're going to put this forward now is in this manner: just force, and then intermediate force options. I'll dive into what those are here in a little bit, and then deadly force. So in the mnemonic, or if you want to call it an equation, but it's really not, you'll see that at the end there's plus. And the first plus is pace. And so pace control, a huge area to discuss. I'll try to boil it down here, but is it through the officer's actions that are maybe exacerbating the situation through the use of poor tactics? Are we making the situation worse? Are we now putting ourselves in a situation where force is now has to be used through the use of poor tactics. And I bring it up because the Ninth Circuit, which we all know we police in, uses a concept called the provocation doctrine in their analysis of use of force. Now, with that, the Supreme Court has signaled many times to the Ninth Circuit to knock it off. They don't like the provocation doctrine use. And a prime case to look at for the provocation doctrine in the Ninth Circuit comes to us out of San Diego. It's Hayes versus San Diego. Be a good case to look at to kind of put it into context. But through the officers' tactics, it was a suicidal call. The officers went inside to effect a welfare check with little to no information and ended up getting involved in an officer-involved shooting. And so the argument was, well, we called the police to come help, and they shot him, and that's not very helpful. And so there was a case out of Los Angeles, the Mendez case, where use of force instructors thought, well, finally, this is going to remedy the provocation doctrine. It's going to put the final nail into the provocation doctrine. And I ended up talking with an appellate deputy district attorney, or a deputy prosecutor, I should say, an appeals deputy prosecutor about it. And his explanation was, it doesn't really do what law enforcement may think it does regarding use of force in relation to the provocation doctrine, because there's still civil liability involved with it. And so we've seen, even recently, another case, Beltran-Serrano v. City of Tacoma, the provocation doctrine reared its head again. So I think it's important to talk about it, and it speaks directly to pace and tactics and using things like time, distance, and shielding and hard cover. And then the second plus is the probable cause standard. The standard for officers to operate in a use of force situation is PC to believe. It's not reasonable suspicion. And so a common question that comes up from recruits when they see this, they talk about it, and they go, well, doesn't that mean I thought I could use reasonable suspicion to conduct a Terry stop? And yes, that's true. That's for the detention. That's the standard of the ability for the officer to detain. The use of force is actually a PC standard, and really the courts are really talking about it heavily in the use of deadly force. Does the officer, or did the officer, have probable cause to believe that if not immediately apprehended, the subject poses what they say is a significant threat of serious bodily injury or death? Some say immediate, some say imminent. I'm going to show you a case later in this curriculum where it puts it into better perspective, because the fleeing felon had committed a very violent crime and was still in the acts of violence in his flight, and the officers ended up using deadly force to stop him. But the standard is for use of force situations is probable cause, not reasonable suspicion. So examples of force include that type of force which is not intermediate or deadly. And so presence, an officer shows up, they're in uniform. We all know that doesn't always have an effect on people, but it is an element of force. Verbal commands or orders, were they given, or were they ignored and or obeyed or disobeyed? Display of force option. So if I'm displaying my firearm, I'm displaying my baton, or I'm displaying a taser or something along those lines, that would fall under force. It's now, of course, department policy dependent on reporting issues. Follow your agency policy on that, but it's not the use of deadly force until I pull the trigger. So that would fall here under display of force option. Touching. So escort position, any direction, shoulder turn entries into handcuffing, guidance, things along those lines would fall under the category of force. Intermediate force is a really vast area to talk about in the use of force as a whole. So intermediate force involves things like impact weapons. In targeting areas such as the primary and secondary targeting zones, not anything tertiary that could cause serious bodily injury or death. Personal impact weapons as well, so hands, feet, knees, legs, or tools, baton, or even the delivery of extended range impact tools, so things like single launchers, beanbag shotguns, Sage-Co's, things along those lines. And of course targeted towards primary and secondary targeting zones. Taser or your electronic control devices, or ECW, whatever we're calling it today, seems to change sometimes, but that device would fall under intermediate force. We know there's two types of ways to deploy taser. Via drive stun, which is deemed less intrusive than probe mode. And then OC. OC can be delivered via extended range delivery systems as well. So Pepperball primarily as an extended range delivery system. When you start talking about gas delivery, that gets into the SWAT and realm, which is another area of force entirely. I'm not going to go into that. And then we come to deadly force, and deadly force historically means any means likely to produce serious bodily injury or death. Any means, usually, especially recruits default to, well, it's just only my firearm. Makes sense, to default to that option, but it can be in many different ways. The striking of a tertiary target with an impact weapon, or weapons of opportunity, or things like that. If deadly force is applicable, then it means really any means likely to produce serious injury or death. The RCW definition for deadly force is right here under 9A16. It means the intentional application of force through the use of firearms or any other means reasonably likely to cause death or serious physical injury. The Graham factors, again, in Graham versus Connor, Graham is present in every use of force. Simply put, they're always there, whether the use of force was deadly force or not. And they're going to ask these questions. We've talked about that. Those are always going to be asked. Now, the plus to Graham, there are many cases that talk about the plus concept for consideration in the Graham factors. Here are some cases that highlight that. Chu versus Gates, Ninth Circuit. Glenn versus Washington County is also in the 9th. Scott v. Henrich, also 9th. And then Plakas v. Drinsky is an interesting case. It's out of the 7th, but it speaks to this as well. And here's what it is. Here's the plus. It's were there reasonable, less intrusive alternatives to the use of force that was utilized by the officer. And again, I think it's important to note that reasonable, not all alternatives, but were there reasonable ones? Was there time? And we know that we don't always have the luxury of time, but if there's time to consider less intrusive alternatives, then we should. What really is an immediate threat, and how can that be construed as an immediate threat? The nature of the suspect's flight or resistance, any resistance can pose a threat to our endeavors. And so whether the suspect is an immediate threat to the safety of the officer or others is generally considered the most important governmental interest for using force. And the more severe the crime and the more robust the resistance is, then the more intrusive that force may be. So simply put, the greater the threat, the greater the force that is reasonable. Severity of the crime makes a difference. It's a big factor. What is it that you're dealing with? Is it a low-level misdemeanor crime? Is it a egregious violent crime? Is it somewhere in the middle? It generally refers to the reason for seizing or making someone submit to our control in the first place. And arrests and Terries or investigative detentions are traditional governmental reasons for seizing people. The government does have an interest in investigating crime. It's just we need to weigh that interest with what it is that we're doing with our use of force. So generally, the more serious the crime that is at issue, the more intrusive the level of force may be, or the degree of force. active resistance, and if it frustrates governmental interests in several ways, and obviously it prevents the officer, it can, from effecting an arrest or investigating a crime or controlling a traffic stop or executing a search warrant. And flight does the same thing. Flight frustrates our interest as the government to investigate crime in the same way during attempts to escape. The objective reasonableness standard, what is the test? What is it? So the courts say that, and it doesn't always feel this way, that they can't use 2020 vision of hindsight in their analysis of what we did at the time. And although it says that it's supposed to be judged through the lens of the perspective of a reasonable officer on the scene rather than with 2020 hindsight, it doesn't always feel that way because questions get asked of, well, couldn't you have done this or couldn't you have done that? I've actually seen that happen in trial. So the theory is that you're not supposed to use vision 2020 hindsight. It was what was at the time the force was used. But here's where that gets murky, is with the Ninth Circuit's provocation doctrine. They rewind the tape a little bit. They look at, yes, at the moment force was used, was it reasonable? But what were the events that led up to that use of force, is what the Ninth Circuit commonly does. So that kind of feels like 2020 hindsight. So it gets a little murky there. But the objective test requires the court to look at a reasonable officer. And what is a reasonable officer? And so they'll look at the officer involved, and they'll say, based on this officer's training, background, experience, could is the question, not should, but could such an officer believe that the force this officer used was reasonable? Would they have come to the same or similar conclusion under the same or similar circumstances? And since the objective test judges us through that lens of the reasonable officer, subjective beliefs, whether they're good or bad, they're not relevant. The courts don't consider that. So what do I mean by that? I mean that the use of force itself won't be tainted if by the officer's ill will towards the subject. Flip that, and an improper or an unreasonable use of force won't be repaired by nice thoughts or no ill will. Motivation, state of mind are simply irrelevant, meaning it's facts. What were the facts that made the use of force reasonable? So just a little bit more on the objective reasonable standard and the test. In short, facts make force reasonable. The test requires the officer rely on their senses. What did you see, hear, smell, taste, touch? And then articulation of that factual basis for what you did. And it should be obvious to all of us by now that, and we know, but the recruits don't know, that you have to help the court visualize what happened. They were not there. So using good action verbs in a written report makes that possible. It helps the court to be able to understand and put it into context of what the facts were at the time. And we should avoid statements like, the suspect indicated that they would not do as I ordered. Well, what do you mean by indicated? What did they do? Or the suspect suggested that they had a weapon, or they implied that they would fight me. So those statements really raise more questions than they answer. So what did they do? Spell it out for us. What was the behavior? What was the demeanor taking place at that time? And cop talk creates that same confusion. So when we say things like, well, the subject displayed pre-attack indicators. Okay, well, obviously, what do you mean by that? Well, we mean stance. We mean a pugilistic or a fighter's stance. One leg was bladed back or positioned back further than the other. The suspect's hands were above their waist with clenched fists. I could see muscle tension, all of those things that would fall into that category. But rather than just give the blanket statement of pre-attack indicators, it's like when officers say things like, well, I did it for officer safety. No, sorry, but that's just not good enough. It doesn't cut it. So we need to really push the articulation and the recognition of behavior. And we talked about this briefly, just to kind of touch up on it again. No 2020 hindsight rule. The courts are supposed to analyze at the moment the force was used, what was reasonably known to the officer at the time. But again, with some of the other things we've talked about, it doesn't always feel like that. It gets a little confusing in there, especially when we're talking about the Ninth Circuit's provocation doctrine use. What officers learn after the fact, not relevant under the objective test. So let's say this is an unknown person you've never dealt with before, you don't know anything about their history, and it becomes necessary during the detention to use force. Force is used, and now you find out after the fact that the subject had a murder warrant out. Doesn't come into the calculus. It doesn't enter in. We learned that after the fact. It's what did the officer know at the time? And again, what were the facts? Facts make force reasonable. So what were the facts reasonably known to the officer at the time? And there are no perfect answers. Like directly back to the opening slide of this thing, when I read to you that quote from the National Institute of Justice, even the Supreme Court says the test for reasonableness, or trying to determine was the use of force reasonable under the Fourth Amendment, is not capable of precise definition or mechanical application. And the interesting thing about that, my opinion, is that right there speaks directly to use of force continuums. I made the decision to recommend, and our agency did, remove a force continuum from our policy. It depends on who you talk to. Some say they're an absolute must, and some say you absolutely have to take them out of your policy. I think that a use of force continuum is an attempt to make a precise definition or mechanical application based on the levels in a force continuum, which is why I chose to make the recommendation to go to what's commonly referred to as an amendment-based use of force policy. Some people call it a JBR model or just be reasonable model under Graham. But that was this is one of the big reasons why I made that recommendation. Not to say that they're bad, but they weren't intended in the first place to go into policy. They kind of just crept in. What it was a training tool. It was a guide, and then they actually came into hard policy. But the courts do give us this. The good news is that they know that we do a tough job, and they say that as much. They know that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. Those are the key words right there. Regarding the amount of force that is used, but we know this, that not every interaction with a citizen is going to fall in this category, though. But when it does, the courts know that those are the conditions under which we have to make a determination. And then obviously there may be more than one way to affect a seizure in such a circumstance that's tense, uncertain, and rapidly evolving. And so when one uses hindsight to show that, well, you could have done this, why didn't you do this, to prove that one option might have been better than another, what really matters is whether the chosen option at the time was within the realm of reasonableness. So the courts say that an officer's use of force must take into consideration the nature and level of intrusion weighed against the governmental interest at stake. And that sounds like a mouthful, and it is, and it sounds confusing. And so the court stated that the reasonable use of force requires this careful balancing of the nature of the intrusion on the suspect's liberty against the countervailing governmental interest at stake. And so when I read that, or I say that to the recruits, they look at me like I'm from outer space. And it does sound complicated. I agree. And it's hard to say. And it's actually pretty simple. So this is the way it was broken down to me by Tim Miller with FLETC. And I really like how he does this. So what did the officer do? That's the nature of the intrusion on the suspect's liberty. Did the officer go hands-on? Did they use handcuffs? Did they conduct a frisk? Were they in the force realm? Were they in intermediate, or was it deadly? What did they do? And what's the governmental interest means? Why? Why did the officer do what they did? What was the severity of the crime? What was the justification for the detention and intrusion at the inception, at the very beginning? And the government does have an interest in the investigation of crime. But I do want to highlight this. When there's cases involving an EDP or an emotionally disturbed person, the interest of the government at that point is actually decreased. It's diminished when there's no element of crime. So we're talking about suicidals. We're talking about emotionally disturbed people, where there's the overriding factor is medical. It's not criminal. That interest is not very robust at that time. Not to say that we're not there to help people within reason, but it is not a overriding, super compelling interest of the government at that point, which is why we're seeing the pendulum kind of swing back towards now when we're dealing with individuals who are suicidal. There is no homicidal ideation. We have none of that information. They are strictly a threat to themselves. They are contained, let's say, within their own residence. There is nobody else within inside to cause harm to. Then we're seeing agencies and police officers either passively monitor those situations or walk away from them and not push an issue that's not criminal, and not push an issue that doesn't need to become one in the first place. So we've seen incidents like that where the officers decide under those circumstances that it was reasonable to make an entry into that environment, and lo and behold, it results in a use of deadly force and problems arise. So and lives are lost. So EDP's governmental interest is diminished when there's no element of crime. So additional factors are considered in a case such as Brian v. McPherson was Ninth Circuit. The court said that. They said that, yes, the Graham factors are there. However, they don't exist in a vacuum. They're not exclusive. Other factors are considered. So when you see things like the 6 situational factors, those are other factors that may come into play and will come into play in an officer's use of force. So under the totality of the circumstances, additional factors considered in an officer's use of force are the availability of, and we've heard this, of less intrusive alternatives. Was the officer pushing the pace and condensing time and compressing it and creating a situation where an increased level or use of force had to be used? Were there proper warnings given? We know that it's not always feasible to issue warnings, but it will never hurt your use of force. And was it apparent to the officer that we were dealing with an emotionally disturbed person? In McPherson, it was an odd situation, as a lot of them are. The subject actually stepped out of the vehicle, was wearing boxer shorts, and was screaming and pounding on his steering wheel, yelling gibberish. He was really upset. He was having a horrible day, is what was going on. And so from about 25 feet away, the officer deployed his taser, and the courts in that case said unreasonable. So at that point, we now brush up against less intrusive alternatives to the use of force, and then warnings, and then also the emotionally disturbed piece as well. So, excuse me, just some of the facts in Glenn, briefly. Lucas Glenn, 18 years old. Ultimately, he's shot and killed in his driveway by Washington County deputies. How did this start? He actually came home drunk and highly intoxicated and distraught. So his mom ended up calling 911. That wasn't the first option that she chose. She actually chose to call 2 of his friends prior to that. But during this time, Lucas began to threaten to kill himself. He had a pocket knife, and then he was breaking some household property. Within 4 minutes of the arrival of the deputies, Lucas is shot with a less lethal beanbag shotgun. He's actually hit with it 6 times, and then in conjunction with that, he's shot 8 times. There's 11 total shots fired, but 8 of them struck him, and he dies. So his mom filed suit against Washington County, alleging under a state wrongful death claim and a 42 U.S.C. 1983 excessive use of force claim under the 4th Amendment. And so this was in 2006. Lucas went to a football game at Tigard High School with his girlfriend. During that time, he must have found or located intoxicants. He became very intoxicated. He was in that state when he got home. He had no prior criminal history or any history of violence. He gets home at about 3 o'clock in the morning, very agitated, intoxicated. And like I said, he wanted to ride his motorcycle, and his parents said no, obviously. So Lucas became angry. He started to damage the front door and windows of cars that were parked in the driveway. And they'd never seen him in this state before. They'd never seen him drunk. And so the first thing they actually did was call two of his buddies to attempt to calm Lucas down. And so during this, Lucas had a pocket knife on him, and so he takes out the pocket knife and he held it to his own neck and was threatening suicide. So obviously they thought that Lucas was going to harm himself, so she called 911, believing that officers, certainly the officers would have the expertise to deal with an emotionally distraught teenager. So she does. She calls 911. And advises dispatch that Lucas had a pocket knife, and was stating that he would kill himself if the police responded, and that he wasn't going to leave until the cops showed up and shot him. She also requested paramedics to respond because of the state Lucas was in. She did advise there were hunting rifles in the home, but he didn't have access to them. So Deputy Gerba, he was working an off-duty assignment at the time, and he hears the call come out over radio, and so he elects to respond to the incident. As this call was unfolding, they were establishing a prearranged staging area, but Deputy Gerba, for whatever reason, went directly to the scene at 3:11. So he didn't go to the prearranged staging area, just went straight to the scene and was the first officer. So once Gerba gets there, he proceeds up the driveway and he positions himself about 8 to 12 feet away from Lucas. He has an unobstructed view of Lucas and sees him standing in the garage near his parents and one of his friends. So he sees there's no physical altercation with anyone. He's not threatening anyone else with the pocket knife. No one was trying to flee from him either. They were simply trying to calm him down. He was, however, holding the pocket knife to his own neck. Deputy Gerba's actions were described by others at the scene from the moment of his arrival as what we would probably commonly refer to as extremely amped up, screaming verbal commands such as drop the knife and or I'm going to kill you. No comments of persuasion or cajoling to drop the weapon, no rapport development. It doesn't appear at all. They described Deputy Gerba's behavior as he was angry, frenzied, and really jumpy. And witnesses said that they were shocked by how the deputy was approaching the situation. And then Washington County Deputy Metesky arrives next, right seconds after Gerba. Well, I guess more 1 minute after Gerba arrived. So now we have two deputies on scene. So like Gerba, Metesky was initially going to head to the staging area. However, he heard that Gerba got there, and so he elected to go straight to the scene. When he gets there, he also takes a position relatively close, about 6 to 12 feet, also with an unobstructed view of him, who he was standing in the garage. Metesky draws his firearm as well, also begins to scream and yell expletives and commands such as drop the knife or you're going to die and drop the fucking knife. And similarly to Gerba's behavior, witnesses also described Deputy Metesky in the same way, really frantic and excited. And Lucas's friends both pleaded with the deputies to calm down, that Lucas was only threatening to hurt himself. So at some point in this, within that 4 minutes, the deputies ordered Lucas's friends to step behind them and also ordered the parents to go inside the home, and everyone complied. So everybody is either behind the officers now or inside of the home. So at about 3:14 hours, Corporal Mooser advises the deputies that backup is on the way, probably coming from that pre-staging location. And then Sergeant Wilkinson advises the deputies over the radio There's radio traffic of this apparently where he says, remember your tactical breathing, and if you have distance, that a less lethal option of a taser may be appropriate. So already the consideration of less lethal going on there, actually by a sergeant who's not on scene, but trying to remind the officers of these things. And neither deputy was carrying a taser or less lethal option, such as an extended range impact weapon. There was none of those were on site, which I was having a conversation the other day with someone asking about the carrying of taser and OC. And I believe, I'm a proponent of that officers should carry every force option on them for incidents just like this, to have options available. So Officer Andrew Pastor of Tigard PD, he responded. He had a beanbag shotgun, also a taser. However, nobody requested the use or consideration of a taser at all during this incident. The only time that was mentioned was from the sergeant who was not on scene. He made the recommendation, but after that, it was never came into play. So immediately after the Tigard PD officer arrives, the deputies order him to deploy the beanbag shotgun, and he does 6 times, and it did seem to take effect, because they described him as appearing surprised, confused, and possibly in pain. So I've seen a beanbag shotgun deployed in the field. I've seen Sages as well deployed in the field. I've seen the effect of a beanbag shotgun on somebody, and it hurts. And there definitely was a result and a change in behavior when I saw that. And so, as you would think, as a result of getting beanbagged 6 times, there's behavior that happens as a result of that. He dropped his hands, he grabbed his pants, and he began to move away from the beanbag fire because it was probably painful. And at that time, both the deputies with Washington County had independently determined on their own that if Lucas made a move towards the house with his parents inside, that they were going to use deadly force. So after Lucas takes 1 or 2 steps after getting beanbagged, both deputies fire 11 shots in total, 8 of which strike Lucas in the back, his chest, stomach, shoulder, and legs. And all the lethal fire occurred before the last beanbag round was fired, and less than 4 minutes after their arrival on the scene. Initially, the officer's use of force was considered a non-violation of his Fourth Amendment rights, and therefore the officers were entitled to qualified immunity, at least initially. And then things changed. The U.S. District Court of Appeals of the Ninth Circuit had jurisdiction to review, and they did, and they reversed that decision, stating that the material facts of the case that were in factual dispute was appropriate to go before a jury. So further, with Glenn, the court's always going to ask those factors, the Graham factors, again. There they are. Those questions are always going to be inquired upon by the court. However, when determining the facts of the case, the court is going to go with the version of the events most favorable towards the moving party or towards the plaintiff's view of the incident. And why do the courts do that? They do that essentially because if they didn't, it is said that the plaintiff would never have their day in court. So that's why they do that. So the first question is, based on that version, was there a constitutional violation that occurred? If the answer to that is no, then essentially we're done. But if the answer to that is yes, the courts are going to then default to the second question. And that question is, was that constitutional violation that occurred, is that well established in the law? So in other words, would a reasonable police officer, or should they know better? Is it? Some people say, what would 99 out of 100 officers do? I don't tend to use that as much as just say, would a reasonable officer, based on that officer's training, background, and experience, know better? And if the answer to that is no, it's interesting because even in a situation like this, if it is deemed not well established, the officer still can receive qualified immunity. And we've seen that happen many times. But if the answer to that is yes, then obviously problems arise. So just a little bit further on factors that are considered. So in Glenn and others like it, the courts acknowledge that the Graham factors, they're not all inclusive. They don't exist in a vacuum. So again, I think we previously hashed this out pretty good, but there are other factors aside from Graham, and those are these. Also, I would throw in the 6 situational factors as well into that calculus. And of course, the Ninth Circuit's provocation doctrine. It's interesting in Glenn because I believe what predicated the officer's use of force, of deadly force in this situation, was their determination that they independently made regarding whether Lucas made a step towards the residence where a portion of his family was. So it wasn't really a self-defense case. It was a defense of others shooting, in my opinion. So that kind of changes it because they did not employ deadly force in defense of themselves per se. The overriding factor was defense of others. And so, but is the provocation doctrine still there? And could that be used? Bottom line is did the officers create their own jeopardy, or did they create the circumstances or a situation where force then became necessary in their pre-shooting conduct? It's also called officer-induced jeopardy through the use of poor tactics in decision-making and lack of pace control. So to the RCW definitions, some of the definitions that I'm going to cover are mostly 9A 16 in definitions. There's also one 1031 that we're going to take a look at here as well. We'll start off with the definition that we're all very well acquainted with, the definition of necessary. I know I went through the academy in 1998. I can still recite this in my sleep. I know all of us can. And it's the same. It has not changed. No reasonably effective alternative to the use of force appeared to exist, and the amount of force used was reasonable to affect the lawful purpose intended. A great question to ask at inspections as well to see where they're at on that. And moving on to the definition of deadly force, it's the intentional application of force through the use of firearms or any other means reasonably likely to cause death or serious physical injury. And so, again, I know we said this before, but I think most of us, automatically are going to default to the use of the firearm, but it clearly means anything that the officer does that could result in serious physical injury or death. So just a review of use of force when lawful. This isn't specific just to police. This applies to the public as well. So I'll just highlight these briefly here. I'm not going to read them verbatim. We're all pretty familiar with those. But I think the important point here is that this isn't specific to police. This is for everybody. Again, just to finish off 16020, and when force is lawful in the state. Number 4 is interesting because with citizen's arrest, I've never actually had someone show up at a precinct or a station with someone in custody in handcuffs and told that they held probable cause for the arrest of somebody. I've never actually seen that, but I've seen variants of that where somebody is using force to either detain or subdue someone who they believed were unlawfully in a building or on real property, or were holding someone at gunpoint, or things along those lines. But I think it's also important to note that the public's use of force has to fall under the realm of reasonableness as well. And in situations like that, the question I have is, and I've seen this, can someone who is affecting a detention under those circumstances overstep the bounds of reasonableness and actually be culpable of crime? And I've seen that. I've actually had situations where bounty hunters have been placed under arrest because they stepped outside of the realm of reasonableness. Point number 5, Carrier of passengers, a lot of the times with transit, we have, there's conduct on buses that is deemed unlawful. And can a carrier or a driver of such a conveyance use force to expel someone off of it? And they can, so long as it's reasonable. And then point number 6, regarding the mentally ill, force can be used. It can be reasonable. It has to be reasonable when used by any person to prevent mentally ill or mentally incompetent or disabled person from committing a dangerous act to any person, or enforcing restraint for protection for the restoration of health as well. So that wraps up 9A 16020. Under 1031.050, officers, this is specific to police now, speaking directly to the police use of force. You may, obviously, if after the notice of the intention to arrest the defendant, they either flee or forcibly resist, the officer may use all necessary means to effect the arrest. This is a reason why I like to, once an arrest determination has been made, I am a proponent of making that well known right from the outset, so there's no more confusion. Simply stating you are under arrest. That satisfies this requirement here in the RCW. By simply telling them, it is helpful towards the law enforcement use of force. So as far as today goes, this will be our last slide, and I just want to address quantum of force. And I really want to emphasize it because it's a wide-reaching concept or an idea in the use of force realm. I know earlier I talked about Taser International's litigation expert, Michael Brave, who coined this term. And I'm not sure if with the switch over to Axon, if he is still in that role. It wouldn't surprise me if he is. But Taser, the last version I knew of that they had put out before I left and went to the academy, and before the whole switch over to Axon, was, I think it was version 22. And along the evolutions of Taser's curriculum, you could see that there were recommendations where Taser International was recommending where it wasn't a good idea to use Taser under certain circumstances unless deadly force was applicable. So circumstances like someone under motion, or on a bike or a motorcycle, or behind the wheel of a running operational motor vehicle, on an elevated platform, in water, with the concern being drowning, not electrocution. So things like that, where what's the reasonable likely outcome here? If I do X, what's likely going to happen? If I have someone who's standing on top of a vehicle and I tase them, and the taser works as designed in probe mode, and NMI is achieved, then what's the outcome? Well, obviously the outcome is a neuromuscular incapacitated free fall, and this person is going to fall and likely sustain some pretty significant injuries. So, but quantum of force doesn't just apply to Taser, and it applies, it's wide reaching. It goes across the board of force overall. And I was talking with Rich Lee the other day about this, and it really made me think that we really need to push the emphasis on this overall in the use of force. So anytime we put our hands on another, or we use force, quantum of force is there. What's the reasonable likely outcome? Now, we know that altercations and violent encounters are really, what are they? They're fights, and fights are fluid, they're dynamic, and they're unpredictable. As much as we like to think we can predict what's going to happen, it's almost impossible to do that. So is the consideration there is really what we're looking at in the realm of reasonableness. So thank you for your time today. I appreciate it, and stand by, because there will be some more use of force presentations to